In just 91 seconds, a single question from Judge Amy Coney Barrett would expose a constitutional crisis so profound that every person in that courtroom went completely silent. Representative Jasmine Crockett stood at the podium, confident in her airtight argument. But what happened next wasn't just a legal defeat. It was a masterclass in judicial precision that would be studied in law schools for decades. The cameras were rolling, the nation was watching, and in those 91 seconds, everything Crockett thought she knew about constitutional law was about to be dismantled, piece by piece, word by word, in front of millions of Americans. This is the story of how one Supreme Court justice used nothing but logic, precedent, and razor-sharp questioning to completely freeze the highest court in the land. Before we dive into those explosive 91 seconds, you need to understand what was really at stake here. This wasn't just another routine Supreme Court hearing. This was a case that would determine the future of executive power, congressional oversight, and the very balance of power that holds our democracy together. Representative Jasmine Crockett had arrived at the Supreme Court that morning with a 200-page brief, backed by 3 constitutional scholars, and what she believed was an unshakable legal argument. She had prepared for months. Her team had war-gamed every possible question. They thought they were ready. They weren't. To understand how we got here, we need to rewind 6 months. Congress had been investigating potential overreach in executive actions related to federal appointments. Representative Crockett, a rising star in the House Judiciary Committee, had become the face of this investigation. She had built her political career on being unshakable under pressure. A former civil rights attorney, Crockett had gone viral multiple times for her sharp questioning during congressional hearings. She knew how to command a room. She knew how to make her points stick. But the Supreme Court isn't a congressional hearing room, and Judge Amy Coney Barrett isn't a nervous cabinet secretary. Barrett, appointed in 2020, had already established herself as one of the most intellectually rigorous justices on the bench. A former law professor at Notre Dame, she was known for asking questions that didn't just challenge arguments, they exposed the fundamental assumptions underlying those arguments. Legal scholars had a term for her style: surgical precision. She didn't attack, she dissected. The case that brought them together involved a congressional subpoena that the executive branch had refused to honor, citing separation of powers. Crockett's argument was straightforward. Congress has constitutional authority to investigate the executive branch, and no president is above the law. It was a strong argument. It had precedent. It had public support. But it had one fatal weakness. A weakness that wouldn't become apparent until those fateful 91 seconds. The morning of the hearing, the Supreme Court chamber was packed. Reporters had been lining up since 5 a.m. This was the kind of case that defined careers and shaped constitutional law for generations. Crockett entered the chamber with her legal team at exactly 9:47 a.m. She wore a navy blue suit, power colors, her consultants had told her. She carried 2 binders, one with her prepared remarks, one with anticipated questions and her responses. That second binder would turn out to be completely useless. The hearing began with the usual formalities. Chief Justice John Roberts outlined the case. The attorney representing the executive branch made their opening arguments, claiming absolute immunity in certain contexts of congressional oversight. Then it was Crockett's turn. She approached the podium with confidence. Her opening statement was powerful, invoking historical precedents from Watergate to the Clinton impeachment. She quoted founding fathers. She cited case law stretching back to Marbury v. Madison. "The Constitution is clear," she declared, her voice steady and strong. "No branch of government operates in isolation, no official operates above accountability, and no president, no matter their party, can simply refuse a legitimate congressional subpoena." The courtroom was silent. It was a good opening. Even the justices seemed to be listening intently. Then Judge Barrett leaned forward slightly, the tell that every Supreme Court lawyer learns to recognize. She was about to ask a question. "Counselor Crockett," Barrett began, her voice calm and measured. I want to make sure I understand your argument correctly. Crockett nodded, ready. This seemed like a softball, a clarifying question. You're arguing that Congress has broad investigative powers under the Constitution, correct? Yes, Your Honor. Article 1, Section 8 grants Congress the power to investigate matters related to its legislative function. Barrett nodded. And you're specifically arguing that this power extends to investigating executive branch officials, even in areas traditionally considered part of executive privilege. Correct, Your Honor. While executive privilege exists, it cannot be used as a blanket shield against all congressional oversight. Another nod from Barrett. So far, this was going exactly as Crockett's team had planned. Then Barrett asked the question that changed everything. Can you tell me, Counselor, under your interpretation of congressional investigative powers, what would prevent Congress from issuing a subpoena for the President's private medical records? Not relating to official duties, but purely personal medical information. The courtroom got quieter. Other justices looked up from their notes. Crockett hesitated for just a fraction of a second, but in Supreme Court arguments, hesitation is blood in the water. Well, Your Honor, there would need to be a legitimate legislative purpose. And who determines what's legitimate? Barrett interrupted gently. Under your framework, who decides whether Congress's stated purpose is genuine or pretextual? Crockett felt the ground shifting beneath her. The courts, Your Honor. The judiciary reviews whether... So you're saying that every congressional subpoena dispute must come to federal court for us to determine whether Congress's stated interest is genuine, in cases where there's a dispute? Yes, Your Honor. Barrett leaned back slightly. Counselor, do you know how many subpoenas Congress issues in a typical year? Crockett did know. She'd prepared this statistic. Thousands, Your Honor. Thousands. And under your framework, any official could challenge any of those subpoenas, and we'd need to have federal judges across the country making case-by-case determinations about whether Congress's stated purpose is genuine or whether they're really just conducting a political witch hunt. The term witch hunt landed like a grenade. Crockett knew Barrett had just quoted exact language from political debates without attributing it. A subtle way of highlighting how her legal argument could become a political weapon. Your Honor, the courts have managed. Managed? Let's talk about management. Barrett's voice remained perfectly calm, but the precision was increasing. In your brief, you cite United States v. Nixon as precedent for congressional oversight. But in that case, the Supreme Court acknowledged a presumptive privilege for presidential communications. You're now arguing that Congress can overcome that privilege simply by asserting a legislative purpose. How do you reconcile these positions? 60 seconds had passed. 31 seconds remained. Crockett could feel the argument slipping away, but she had to respond. Your Honor, Nixon was specific to criminal proceedings. This is about congressional oversight, which has different constitutional grounding. Really? Barrett flipped open her own copy of the brief. On page 47, you argue that congressional investigative power is as fundamental to Article 1 as criminal prosecution is to Article 3. Those are your words, correct? Yes, Your Honor. So when it's convenient for your argument, congressional power is equivalent to judicial power. But when we cite a case limiting that power in the judicial context, suddenly they're completely different.
75 seconds had elapsed. 16 to go.
Crockett tried to recover. Your Honor, what I'm saying is... Let me ask you this, Counselor, and please think carefully before you answer. Barrett's voice dropped slightly, not in volume but in intensity. Every attorney in that room knew this was the kill shot coming. If Congress can issue a subpoena for any information it deems relevant to any potential legislative purpose, and if Congress itself gets to decide what's a legitimate legislative purpose, and if the only remedy is after-the-fact judicial review that takes months or years.
Haven't you just described a system where Congress has functionally unlimited investigative power over the executive branch?
85 seconds. The question hung in the air like smoke, because it wasn't really a question, it was a trap. If Crockett said yes, She'd admitted that her interpretation violated separation of powers. If she said no, she'd have to explain what limits existed, and she had already argued there were none beyond the vague notion of legitimate legislative purpose. Your Honor, I wouldn't characterize it as unlimited because... Time, Barrett said simply. 91 seconds exactly. The Chief Justice nodded. Thank you, Counselor. We'll hear from Respondent's counsel. And just like that, it was over. What happened next in that courtroom was remarkable in its silence. Legal experts who were watching would later describe it as one of the most devastating exchanges they'd ever witnessed. Crockett returned to her seat. Her co-counsel leaned over to whisper something, but she couldn't hear it over the sound of her own pulse pounding in her ears. The attorney for the executive branch stood up to present their side of the case, but he barely needed to argue. Barrett's 91 seconds of questioning had already done the work. When Justice Clarence Thomas asked his first question, it was clear he was building on Barrett's foundation. Counselor, Judge Barrett raised the issue of unlimited congressional power. Can you address what practical limits exist under Respondent's interpretation? When Justice Brett Kavanaugh spoke, he went further. It seems to me that Judge Barrett identified a fundamental problem with petitioner's argument, that it collapses the distinction between congressional investigation and congressional harassment. How do we maintain that distinction? Even Justice Elena Kagan, generally sympathetic to broad congressional powers, seemed troubled. I'm concerned about the line-drawing problem Judge Barrett highlighted. Can you help me understand where that line is? Barrett herself asked only 2 more questions during the entire hearing. She didn't need to. Those 91 seconds had reframed the entire case. The hearing concluded after 2 hours. Legal analysts immediately began their breakdowns. But they all focused on the same thing: Barrett's devastating cross-examination of Crockett's core argument. CNN's legal correspondent called it surgical. Fox News legal analyst described it as the most effective judicial questioning since Scalia. Even liberal commentators acknowledged that Barrett had exposed a real weakness in the case for expansive congressional power. But here's what made those 91 seconds so significant. Barrett hadn't just won an argument. She had exposed a fundamental tension in American constitutional law that has existed since the founding. The framers of the Constitution intentionally created a system of competing powers. They wanted Congress to check the president. They wanted the president to check Congress. They wanted the courts to referee disputes between them. But they never fully resolved what happens when those powers collide directly. What Barrett understood, and what Crockett's argument missed, was that constitutional law isn't about who has power. It's about how competing powers are balanced. Crockett had argued for congressional power as if it existed in isolation. She had cited precedents where Congress prevailed, but she hadn't grappled with why Congress prevailed in those specific cases versus others where executive privilege was upheld. Barrett, in 91 seconds, had forced her to confront that oversight. This is what separates great judges from good lawyers. A good lawyer argues for their client's position. A great judge sees the entire system and how each decision ripples through it. Barrett understood that if the Supreme Court accepted Crockett's argument, they wouldn't just be deciding this one case. They'd be setting a precedent that could fundamentally alter the balance of power between Congress and the president for generations. And she wasn't willing to do that without Crockett first proving why such a dramatic shift was necessary. Crockett couldn't do it. Not in 91 seconds. Not in 91 minutes. Because the argument, as presented, was fundamentally incomplete. 3 months later, the Supreme Court issued its decision, 7-2 in favor of the executive branch. The majority opinion was written by Chief Justice Roberts, but legal scholars noted that it heavily incorporated the reasoning from Barrett's questioning. The opinion established a new test for when congressional subpoenas can overcome executive privilege, a test that required courts to examine whether Congress had articulated a specific legislative purpose, whether the information sought was actually necessary for that purpose, whether Congress had exhausted other means of obtaining the information, whether complying with the subpoena would fundamentally impair executive functions. It was a balanced test, one that neither gave Congress unlimited power nor gave the president absolute immunity. But what was most interesting was the opinion's footnote 12. In it, Roberts wrote, "During oral arguments, the potential for abuse under petitioner's framework was aptly demonstrated through hypothetical questioning. This court has a duty to consider not just whether power exists, but whether recognizing that power would create systemic vulnerabilities in our constitutional structure." That footnote was referring directly to Barrett's 91 seconds. Justice Sonia Sotomayor wrote one of the dissents, joined by Justice Ketanji Brown Jackson. But even Sotomayor's dissent acknowledged the concerns Barrett had raised. While I disagree with the majority's ultimate balancing, I concur that some framework for judicial review is necessary to prevent abuse. In other words, even the dissent agreed that Barrett had identified a real problem. Representative Crockett gave a statement after the decision was announced. She was gracious, noting that she respected the court's decision even while disagreeing with it. But privately, sources close to her said she had learned an important lesson. Preparation isn't just about anticipating questions you can answer. It's about building arguments that can withstand questions you can't anticipate. Judge Barrett never commented publicly on the case after the decision. She didn't need to. The opinion spoke for itself. But legal scholars began analyzing her questioning style more carefully. What they found was a pattern. Barrett rarely went for the flashy rhetorical victory. Instead, she asked questions that exposed logical gaps in arguments, gaps that, once exposed, became impossible to ignore. One Harvard law professor described her approach this way: Justice Barrett doesn't attack the branches of an argument. She pulls at the roots until the whole tree falls over. That's exactly what happened in those 91 seconds. Law schools began teaching the exchange as a masterclass in effective judicial questioning. The Barrett method, some called it, start with clarifying questions, build to hypotheticals, force the advocate to confront the logical conclusion of their own argument. Let them see the problems themselves. But beyond legal technique, those 91 seconds revealed something important about how our government actually works. For years, political partisans on both sides have argued that we need to strengthen their preferred branch of government. Progressive activists wanted Congress to have more oversight power. Conservative activists wanted the president to have more executive authority. What Barrett's questioning demonstrated was that raw power isn't the answer. Balance is. The Constitution works not because any branch is all-powerful, but because each branch can check the others. When one branch becomes too powerful, the system breaks down. Crockett's argument, if accepted, would have shifted enormous power to Congress, power that could be abused just as easily by Republicans investigating a Democratic president as by Democrats investigating a Republican president. Barrett saw that danger, and in 91 seconds, she made sure everyone else saw it too. This is why Supreme Court justices have lifetime appointments. They're supposed to think beyond the immediate political moment. They're supposed to consider how legal principles will play out over decades through changing political circumstances. Barrett did exactly that. And the court, even justices appointed by different presidents, largely agreed with her reasoning.
There's one more aspect of this story worth noting: the human element.
Jasmine Crockett is a talented attorney and a skilled politician. She had prepared exhaustively for that hearing. By all accounts, she's someone who takes her responsibilities seriously and works incredibly hard. But sometimes hard work isn't enough. Sometimes you face someone who's operating on a different level. That's what happened in those 91 seconds. It wasn't that Crockett made a mistake. It was that Barrett saw angles she hadn't considered. This is humbling for anyone to experience, let alone in front of the nation's highest court with millions watching. But here's what's important. Crockett didn't make excuses. She didn't claim the court was biased. She acknowledged the loss, learned from it, and moved forward. That's the mark of a professional. And Barrett, for her part, never gloated. She asked her questions, made her points, and let the legal analysis speak for itself. That's the mark of a great jurist. In a political environment where everyone wants to turn everything into a partisan battle, these 91 seconds showed something different. Two highly intelligent professionals doing their jobs at the highest level, with the outcome determined by the strength of arguments rather than political loyalties.
So what do we take away from this story? First, that constitutional
Law matters. These aren't abstract academic debates. They determine how power is distributed in our government, which affects every American's life. Second, that questions can be more powerful than statements. Barrett didn't give a speech about the dangers of congressional overreach. She asked questions that made those dangers obvious. Third, that preparation has limits. You can't prepare for every possibility. Sometimes you have to think on your feet, and sometimes even that isn't enough. And finally, that our system still works. A relatively young Supreme Court justice asked penetrating questions. A congressional representative had to defend her position under intense scrutiny. The court deliberated and issued a decision that tried to balance competing interests. That's exactly how it's supposed to work. The courtroom froze for those 91 seconds, not because something went wrong, but because something went right. The system was working exactly as designed. Judge Amy Coney Barrett questioned Representative Jasmine Crockett's argument on air. 91 seconds later, the legal landscape had fundamentally shifted, and America's constitutional system proved, once again, that it can survive even the most intense scrutiny, as long as there are people willing to ask the hard questions and think through their implications. If you found this story fascinating, make sure to like this video and subscribe to the channel. We break down the most significant legal and political moments shaping our country, explaining not just what happened, but why it matters.
What do you think about those 91 seconds?
Was Barrett right to question Crockett's argument so aggressively? Or should the court have deferred more to congressional authority? Let me know in the comments below. Thanks for watching, and I'll see you in the next one.